Good morning.
I'm all on mute talking to y'all. How's it going?
Good morning.
Good morning.
Good morning. Deja, she's so big. It's scary.
Hey.
Good morning. Good morning, Twyla.
Jameson said, good morning, Miss Carrie.
Good morning, Miss Carrie.
Morning. Hey.
Good morning.
Pleasure to see you all this morning for this adoption that we've waited for, and we finally get to consummate today.
Yes.
I waited a minute because I kept seeing some people come in. I think we probably have everybody that we're going to get at this point. And if we have anybody else, I'll surely let them in as well. But I think we will go ahead and get started. It's 9:35. Court calls cause number 2. Court is zooming outside of Kirk County by Zoom and YouTube, obviously, and I don't think we're going to have any issues with that. Mr. Perzer and Miss Sims, if you would please begin the announcements.
Good morning, Judge Richard Perzer, attorney for petitioner, present, ready.
Sonia Sims, I am the attorney for the child. I am ready.
And then, since you're the petitioner, Ms. Woodfox, why don't you go ahead and announce, and we can let Tyla announce at the same time.
Daisha Woodfox, mother or parent. What's your name?
Tyla.
Hi, Tyla.
Say hi, good morning.
Good morning.
Good morning. All right, anybody else that's going to be testifying?
Judge, this is Patricia Rogers with Belong.
Your
Mark's
Honor,
back from our Hill Country Casa.
Go ahead, Ms. Sims, you were going to say something?
I'm sorry, I spoke over Mr. McLemore. I was just saying who's here on behalf of CASA to testify.
I think it's going to be Mr. McLemore. I don't know, is there anybody else here for CASA, Mr. McLemore?
No, sir, it's me.
Okay. And then we've got a whole host of people who have come this morning to watch, and I'm really happy to see that. Anybody else from the department that needs to announce or belong? For everybody? Okay, then Mr. McLemore, Miss Woodfox, and Miss Rogers, if you would all please raise your right hands. Mr. Berzer, you may call your first witness.
Thank you, Judge. I would call Miss Woodfox.
All right, she's been sworn.
Thank you. Miss Woodfox, you're the petitioner in this matter,
Yes, sir.
and you are currently unmarried.
Yes, sir. That's correct.
And Tyla has resided in your home for more than 6 months?
Yes, since she was 5 months.
That's it. And you're asking that the court today grant an adoption and make Tyla yours just as if she'd been born to you biologically?
Yes, please and thank you.
Fantastic. And today, did you have an opportunity to negotiate subsidy with the caseworker?
Yes, I've already got all that done. That's correct.
And so you've had your criminal background check done?
Yes, sir.
Thank you. And you were asking that when the court grant this adoption, that they do a name change. Is that right?
Yes.
And is that name to be changed to Tyla? Well, and Tyla, and you're asking that the court also order a new social security number to be issued to Tyla?
Yes.
Thank you. And we can all see it for ourselves, but how do you have a close bond with Tyla?
Yes. Like she was mine, like I had her myself.
Do you believe it's in her best interest that this adoption be granted today?
Absolutely.
Thank you. With that, I will pass the witness, Judge.
Ms. Sims?
I have no questions. Thank you.
Okay. And Mr. Perzer, next witness?
I would ask that I would call Miss Rogers, please.
Okay.
Miss Rogers, you're the adoption worker with Belong?
Yes, sir.
And have you had an opportunity to observe Tyla in her placement?
Yes, sir.
And do you believe that it would be in Tyler's best interest for the adoption to be granted today?
100% without a doubt. Yes, sir.
And to your knowledge, is there any formalities, any paperwork that needs to be completed to affect the adoption?
No, sir. We have all paperwork filed and everything is ready to go.
Thank you very much. I'll pass the witness.
Ms. Sims?
Ms. Rogers, you believe this is in Tyler's best interest, correct?
Yes, ma'am.
You are here to express the department's consent to this adoption that we have all been waiting for quite a long time.
Yes, ma'am.
Okay, thank you. Pass the witness.
Next witness, Mr. Perzer.
I'll call Mr. McLemore.
All right, he's been sworn.
Thank you, Mr. McLemore. You are the guardian on this case.
Yes, sir.
And how long have you been guardian for Tyler?
For 6 months now.
Excellent. And have you had an opportunity to observe her in her placement with Ms. Wood?
Yes, I have.
And what did you observe?
It didn't seem like a foster home at all. It seemed like a family. They were extremely well bonded. I was really impressed with the whole household, not just the dynamic with Tyler, and it was a wonderful experience.
Fantastic. So you believe it would be in Tyler's best interest for the adoption to be granted today?
It is definitely in their best interest.
Thank you. And no outstanding paperwork that needs to be completed to your knowledge?
No, sir.
Thank you. I'll pass the witness, Judge.
I have no questions. No questions.
Any other witnesses?
No, petitioner rests, Judge.
All right, Ms. Perzer, or excuse me, Ms. Sims, is there anything else that you want to add?
Just that, as the court knows, this has been a long time coming. Tyler has been part of the Wood Fox home for quite some time, since she was very little. She is with her siblings. She is with her mommy. She is with her entire family that loves and supports her. And we would definitely support and ask you to grant the adoption today, including the name change.
Thank you. Anything else that you want to add, Mr. McLemore, if Mr. Perzer didn't ask you?
No, sir. Just like I said, I was really impressed with it. It seemed like a family. There was no foster situation there at all.
Okay. Very good then. Then, having heard the arguments and evidence of counsel, the court finds that this is the court of continuing exclusive jurisdiction. No other court has continuing exclusive jurisdiction, and that this court has subject matter jurisdiction and jurisdiction over the parties. The court finds that all parties entitled to citation and notice were duly cited and served. And the court finds that this child is not only eligible for adoption, but all prerequisites to the adoption have been met, and it's in the best interest to grant the name change that was requested, best interest of the child to grant the adoption in all respects. Can you believe it? We're finally here. Congratulations.
Yay! Oh my God. It was never gonna come. Yay!
The never-ending story is finally ended.
The never ending. Thank you guys so much for all of your help, your support. You guys have been awesome. Stuck by our side through the end. Ms. Rogers, big shout out to you. Thank you so much for all that you have done and just, push this whole process through. I thank all you guys from the bottom of my heart.
Your Honor, may we have permission to snap a photo by Zoom?
Yes. Get in there, Tyler.
Okay, I'm gonna let everyone get centered. Ready? Say cheese.
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 One more. Cheese.
Cheese.
Excellent. I got them. Thank you.
Thank you guys so much for all of your help.
Thank you.
If anybody else wants to say any words of congratulations, you may do so now.
Congratulations.
Thank you.
Congratulations.
Congratulations.
There go TT. Hey, there go VP. Say hi.
Hey, baby.
Congratulations, sis.
Congratulations.
Hey, thank you.
All right.
Y'all for showing up. Thank you for taking the time out of your day to show up for us. We definitely appreciate you guys.
Yes, it's wonderful to see such a show of force on such a happy day.
Yes, sir. Thank you.
Bye.
Thank you so much. I'll get that order to you, Mr. Perzer, and if nothing further, all parties are excused. Bye, Tyler.
Bye. Say thank you.
Thank you.
All right.
No objection.
Aw.
Miss Kyler Green, would you please begin the announcements?
Yes, Shauna, good morning. Emily Kyler Green, attorney for the department.
Alejandra Certuche, belong permanency specialist.
Ashley Crouch, belong permanency supervisor.
Anna Swallow, attorney ad litem for the respondent father, not ready, judge.
Richard Saldivar, attorney for the child, ready.
Sarah Woods, Hill Country Casa, guardian ad litem case supervisor.
Sue Jewell, Hill Country Casa, guardian ad litem.
Miss Jenkins, can you please unmute and announce?
Oh, my bad. Harley Jenkins, mother to Jordan.
Do we know where Miss Savage is?
I just reached out to her, judge.
Yes, and we're not expecting Mr. Miller.
Judge, he may or may not join. If it's appropriate, I can explain my not ready.
Let's see if we can get Miss Savage on real quick.
Okay.
And if we can't get her in the next few minutes, then I will go ahead and let you proceed.
Thank you.
Come back in. Miss Savage, when you get a second, if you could please unmute and announce.
Kathleen Savage, attorney for the respondent mother. I'm ready, Your Honor.
All parties have been sworn that are potentially going to testify, but my understanding is Miss Swallow would like to put some proper some information as to why she's asking for a not ready today. So Miss Swallow, you can go ahead and do that now.
Thank you, Judge. The parties attended mediation on November 19th, and part of that mediation agreement, specifically provision 7, all parties agreed to seek a reset of the final setting. I propounded discovery on the department April 9th of 2024 this year, and I need responses to disclosures. I've received the petitioner's witness and exhibit list, but I haven't received responses to disclosures. And I need a supplemental case file. They sent me a case file. I think it goes through June. It's about 800 something pages, but I don't have anything beyond that point. So I think we have time within the dismissal to reset this hearing, and that's what I ask, and that's what the parties agreed to at mediation.
Okay. Ms. Kylie Green, is that, I don't know if you were at that mediation or not, but is that what you understood the agreement to be?
Yes, Your Honor, I was not at the mediation, but I have read the MSA, and that is what it states.
Okay.
Additionally, Your Honor, I think that the department, I'm not sure on this, but I think the department might need to request that you order the supplemental discovery in order for that to be effectuated quickly.
That was going to be my next question. So you said you didn't get RFD, you didn't get requests or your responses to requests for disclosure, or you didn't get, was that what you said?
Yes, Judge, both.
You don't have a witness list? You don't have a witness list?
I have a witness list. However, specifically, if they're not planning on calling expert witnesses, if they're not planning on using any videos, audios, or photographs, I would like more than just to be handed like this entire huge redacted case file. I would like for them to tell me what it is they're going to use.
I understand. And that was the purpose behind my question, was to, if I order the supplemental file, I don't want the understanding, the misunderstanding to be that supplemental file is going to satisfy your request for specific answers to the request for disclosure that you can rely on. Is that what you're saying?
Yes, Judge.
Okay. What else did you say you didn't get?
So responses to my request for disclosures, and then the supplemental file, redacted file, and then anything, within my request for production, it requests all videos, audios, and photographs relevant to the case, in addition to the de-identified file, and any written policies or guidelines relevant to the case that they plan on using at trial.
Okay. Ms. Kyler Green, is there going to be any issue with that? Usually, it was my experience that the de-identified file would come with a disk and or any supplemental videos and things of that nature. Are we going to have any potential issues making sure that request is fulfilled?
I think that the request has already gone out, Your Honor, but I think that in order to get it expedited, the court order is would be nice. I don't think there's going to be any issues getting that. I don't know if you caught it as well, though. Ms. Swallow has also received an exhibit list that has gone through the exhibits that intend to be introduced at trial. But I understand what else she's asking for.
Okay. All right then. Mr. Saldivar, Ms. Savage, anything you have to add or take away from this?
No, Your Honor.
No, Your Honor.
What sort of time announcement? Two questions. The time announcement for the actual trial, and then how much time does the department need to get all the responses prepared and back to Ms. Swallow?
I don't think I can answer the time announcement, John. It depends on whether the MSA is followed. But in terms of getting the evidence, I would say at least a month.
And Your Honor, the mother will be tendering a relinquishment. So that part of the trial should be relatively quickly. However, we have to prove up grounds for Mr. Miller, probably, I would assume, at least 2 hours, if not a little longer.
I'd be inclined to give it half a day, just in case we don't get that relinquishment. But if I give it half a day, based on what I'm hearing, it'll be half a day. Anybody have a problem with that?
No, Judge.
No, and the mother's relinquishment will be filed here by the end of the day. I have that. It just needs to be filed in the case.
Oh, so you have it from her already?
Your Honor?
I'm sorry, Ms. Savage, I might not have heard you. You're telling me you already have the relinquishment.
I received it this morning, Your Honor, so I need to file it.
I misunderstood you. I apologize. Then were you going to say something, Ms. Connery?
Yes, Your Honor. I was just going to ask if the Samsung G973U1 has been identified.
I didn't see it. It's on the second page for me. The person that's on the Samsung G973U1, did you please get into your video and unmute and identify yourself? Does anybody know who that is? Are you here for the Miller trial, ma'am? You're muted. I can't hear you.
I'm not sure if it's me. My name is Kyra Varner Quiles.
And which case are you here for?
Marlo and Nat.
Okay. That's not this case. I'm going to put you back in the waiting room, okay?
Okay, thank you.
You're welcome, ma'am. Thank you. Okay. I could put you down for the morning on January 22nd. That's, just shy of 2 months. And I know we've got the holidays, so it's probably going to equate to just about a month. But that should be plenty of time. Miss Swallow's making a face like she's got a concern.
I'm sorry, Judge, I'm reading, deadlines just to make sure I'm waiting to hear your order on, when the department is required to supplement.
Well, I was going to make an order that the supplemental file be provided as soon as possible. And Ms. Kyler Green said a month. I would say it needs to be available. Let's look at the calendar and see what business days we have at the beginning of January after the holiday. January 3rd is a Friday after New Year's Eve, or Friday after New Year's, excuse me. And if we're looking at the 22nd, that would give Miss Swallow a few weeks to go over those materials. The dismissal is 2/17, so that trial date is getting pretty close. But I would rather go another week out, or get closer to the dismissal date than have to reset it again.
I would tend to agree, Judge. I would request that the response to disclosures be responded to by the 22nd of December, And then if there's any supplements that it be supplemented within 15 days of the final.
Well, considering, and I don't know what the reason was, but considering technically the requests for disclosure are late, if I'm understanding correctly. So giving it another 18 days, I think is more than fair. If they've had the request since April. And let's see, I think I've got another. February 12th at 10 is another option.
Judge, I'd almost be inclined to be in agreement with the February 12th at 10, just to make sure everything's received in case there's some sort of delay with the supplemental production on the de-identified file.
Judge, I have an in-person jury trial on the February 10th. And to find coverage for a half a day is going to kind of be difficult.
I don't know if we have any other days that close to the dismissal date. Yeah, that's it. If we get if Miss Savage has a relinquishment, then it cuts us down to 2 hours, from what I understand.
Okay.
So if you have problems finding coverage, let us know. Maybe your jury will settle her in early, but if not, I would give you the opportunity, Mr. Salivar, to provide a report if you can't get coverage for some reason. I think you should be able to. But that's the only day that's going to work with all the other parameters I have, unfortunately.
Sounds good, Judge. I'll figure it out, Judge.
Just keep Miss Greenlee informed if you're having problems.
We
might be able to help you enlist some help.
Sounds good.
Okay. All right. Then, unless I need to hear something else, I'm going to order the supplemental file be provided no later than 15 days prior to trial. That date's going to be February 12th, 2025 at 9:30, the trial date, February 12th, 2025 at 9:30. So 15 days ahead of that date, so make sure to check the calendar. And then I'm going to order the specific responses to the request for disclosure to be provided by December 22nd as requested. And then that supplemental file, I want to be clear that the reset order and the discovery parameters of that order include language, Ms. Conley Green, if you would please, that state the supplemental file is to include any and all videos, other exhibits, photographs, and theoretically, all of that should correspond with whatever's in the RFD list or the exhibit list that you sent over. You didn't propound interrogatories, did you?
No, Judge, just production and disclosures.
Okay, so your disclosures and your production need to correspond with whatever falls outside of the file itself, those other tangible pieces of evidence. Okay, what else, if anything, do we need to take up today? When was our last perm? Our last perm was October 2nd. That's 60 days ago. We're coming back in February. I think we're inside the 120, are we not? Might be a little bit outside.
Yeah, 120 is January 30th, Your Honor.
Okay. All right, then. Ms. Santucci, you're the caseworker, correct?
Yes, Judge.
What's our permanency goal right now?
Unrelated adoption.
Is that in the best interest of the child?
Yes, it is.
Okay, and our placement is still foster home in Kendall County?
Yes.
Is that placement safe and appropriate, meeting the child's needs?
Yes, it is.
Is it in the best interest of the child to remain in that placement?
Yes.
Is Jordan up to date on all of the checkups?
He is, and he has his his annuals in January.
Any medical or mental or emotional concerns right now that we need to address?
No.
And any observable issues or delays that we need to discuss today?
No, he's on task.
And at this time, I'm gleaning that neither parent is in compliance with the family plan of service.
Correct.
Not safe to return the child to either parent.
No,
They have not addressed the concerns.
no, they have not.
And it's in the best interest of Jordan to be remaining in the temporary managing conservatorship of the department / belong.
Yes, it is.
And do you believe that Belong has made all necessary reasonable efforts to return Jordan to either parent?
Yes, I do.
Anything in particular that you want to put on the record today as far as reasonable efforts?
So I have not been in communication with Mr. Miller since July, but I was attempting each month to communicate with him and send him to drug test. So those would be some reasonable efforts. And we did also reach out to him via social media.
You both have a copy of the family plan of service,
Yes, they do.
and referrals were made,
Yes,
and you attempted to maintain contact,
yes,
and you all have discussed the permanency goal throughout the course of this case,
yes,
and you made that clear to Ms. Jenkins.
yes.
And is Ms. Jenkins visiting with the child?
Yes, they continue to do virtual visits weekly for 30 minutes.
Are those visits in the best interest of the child?
I would have to disagree that it would be in his best interest at this time. He does not appear to be engaged in those visits. And I don't think there's any benefit. There's no bonding happening.
Is it a hardship on either the child or the placement in order to make these visits work? I mean, even if it's not a crazy onerous hardship, is it a hassle on the child?
It can be, especially times where, like, if mom confirms and then doesn't show up the next day, or if she doesn't show up at all, they sometimes miss out on his nap time, and he does tend to get fussy sometimes when that happens. So I think that would be a hardship on them.
Okay. Ms. Conagher, do you have any questions for Ms. Sototuche?
No question, Your Honor. Thank you.
No questions, Judge.
Ms. Babbage?
No, Your Honor.
Mr. Sullivan?
Yes. To your knowledge, how many visits has Ms. Jenkins missed?
Since July, it's been more inconsistent. I don't have an exact number, but I would probably say it's been about 5.
Okay. Have there been several times where she confirms visitation and doesn't show up?
Yes, for those, I think it's been like twice.
Okay. Pass the witness, Judge.
Anybody else have a witness that want to call?
No, Judge.
Okay. Mr. Saldivar, anything else that you want to report at this time?
Judge, the child's doing great in placement, thriving, meeting all his needs. Judge, I'd be in agreement with stopping the visitation at this time. Visits have been missed. It is an inconvenience to the placement and the child, and we are having a relinquishment filed here soon. I don't think it's in the best interest for those visits to continue until February. I'm okay with a goodbye visit, but after that, I think that the visit should stop at this point, Judge.
Thank
And
you.
Your Honor, response?
I'm sorry?
A response?
Oh, yes, go ahead, Ms. Savage.
Your Honor, there's no motion on file requesting to stop the mother's visits. There's no notice. While these visits may be a nuisance to the foster placement, it's a once a week, 30-minute virtual visit. I'd ask that there not be a change in mom's visits. It's more punitive than anything else. And so I would request that those visits remain intact. If the court is inclined to modify them in any way, that possibly it be suspended if she misses another visit from here to then. But at this time, this is the only parent that's showing up. It's a parent who's making a choice for their child and it seems punitive to stop a virtual visit that really has no actual true burden or hindrance on a child who doesn't have to go anywhere, just gets to hear his mother's voice for a few minutes.
Anybody else want to respond?
Judge, can we get Casa's opinion on the matter?
I was going to ask Ms. Jewell next. Ms. Jewell, what, if anything, would you like to report?
Well, I think the visits are, since she already relinquished her rights and that's being filed, I think the visits are a total imposition. They're hard on the child and they're hard on the foster mom. So I would recommend that they be ceased at this time.
Okay, thank you. Give me a rule on the current hearing and then we will get into this visitation issue. I've already made my ruling as far as the trial reset. I'm not going to repeat all that. As far as the permanency hearing, the court finds that the permanency goal at this time is unrelated to adoption. Court finds that it is in the best interest of the child. Court finds that the placement is safe, appropriate, meeting the child's needs, and in his best interest to continue there. Court finds that the child is up to date on all of his checkups, and court finds that neither parent is in compliance with their family plan of service. It's not safe to return the child to either parent, and they haven't addressed the concerns that brought the child into care. It's in the best interest of Jordan to remain in temporary managing conservatorship of the department / belong. I'm going to find the belong has made reasonable efforts, including attempts to communicate with parents, sending them to follow the drug tests, creating and providing them with family plans of service, making referrals, maintaining contact with the parents, discussing a permanency goal, and then making sure that Ms. Jenkins and Mr. blanking on his name, Mr. Miller, have both received that information. And I'll make a finding that Ms. Tuche has not had any response back from Mr. Miller for, I think by her testimony, in 5, almost 6 months. As far as visitation goes, we have a lot of cases where I understand Ms. Savage's argument that it's not that much of a burden on a child, we can keep doing it. The child can hear child's mother's voice. I feel like this case is distinguishable a little bit though, because she's already relinquished. Hearing testimony that the visits are not very engaged, that there's no, Mr. Tuche's words were there's no benefit or bonding. And Ms. Jewell is reiterating what Mr. Salvador said, that it's kind of a hassle for the child, and that I think she's missed 5 visits in recent months. Sometimes doesn't even confirm or confirms it doesn't show. So if all of that didn't exist, I'd probably entertain your argument, Ms. Savage, but we do have all that and she has relinquished. It's not punitive. It's not the intention. The intention is that it just doesn't sound like it's in the best interest of the child. And there's no motion on file, that's correct, but the court does have the authority to make orders as necessary during these hearings, sua sponte if necessary, to make sure the best interests of the child are being met. And I think at this point in time, considering mom's intention, I'm going to order a goodbye visit, and that's going to be it. After that, the visits are suspended. So I'm not going to set a date and time on that goodbye visit. You all can figure out when it's going to be, but that's going to be the order of the court. And then we'll have our final trial February 12th, 2025 at 9:30. Now, if for some reason mom rescinds her decision, doesn't sound like she's going to, but if she does, then we can certainly revisit this issue with the court. But it's not looking like we're going down that road. So anything else I failed to address?
No, Your Honor. Thank you.
Okay. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you.
Thank you.
Court is streaming by Zoom and YouTube outside of Kerr County. Any objections?
No objections.
No objection, Your Honor.
Ms. Kyler Green, would you please begin the announcements?
Yes. Good morning. Emily Kyler Green, attorney for the department.
Amber Wagner, adoption specialist for Belong.
Richard Sullivan, attorney for the child, ready?
Mark Smackmore, Hill Country Casa case supervisor.
Deborah Admire, Hill Country Casa.
All right, I think somebody's got something playing in the background. If you're able to mute that, that would be helpful. Thank you. Ms. Wagner, would you please raise, and Ms. Admire, would you both please raise your hand? All right. Read both the reports. It looks like everything is basically the same as it was back in July. Permanency goal still unrelated adoption, Ms. Wagner.
Yes, Judge.
Placement safe and appropriate and meeting Ezekiel's needs.
Oh, very much so.
Okay, and Zeke is up to date on checkups and his medical issues are being appropriately addressed at this time.
Yes, Your Honor.
Okay, and he's on several medications and those have been reviewed.
Yes, Your Honor.
And is it the least restricted placement possible?
Yes, sir.
And he's bonded to the placement from what I could read.
Oh, very much so.
Very bonded. And then our only barrier at this time is the appeal.
Correct. We're just waiting for the mandate to come down.
Okay. And then we've already discussed that licensing, redaction, hashtag, all that's already done.
Correct.
And the only, I guess, reasonable efforts that you continue to make in this case are to monitor his progress and monitor the home and his field. Still hearing a lot of noise. I don't know where that's coming from. Sounds like somebody's watching a game. Okay, anything else that we need to discuss today?
Not from the department, Your Honor.
Mr. Sullivan?
No, Your Honor, I think you covered everything. He's doing well, thriving. We're just kind of just waiting for this appeal to end so we can get him adopted.
Okay. Ms. Badmeyer?
Everything's good on Casa's end, sir.
Okay. Then the court finds permanency goal remains unrelated adoption. Placement's good. It's in his best interest to stay there. He's up to date on everything. All is going well as far as that is concerned. And we're just waiting on the appeal. And court finds that Belong has made reasonable efforts by monitoring the appeal, monitoring Zeke and his progress. And it's in the best interest to continue towards that permanency goal. Our next hearing will be a permanency review on May 7th, 2025 at 11 a.m. May 7th, 2025 at 11 a.m. But obviously, we can set this as soon as the appeal is, the mandate's received. Just let Ms. Greenlee know that we're ready. Is there an adoption attorney?
Yes, I'll get with the placement judge and give him an adoption attorney.
Okay. Let them know that get everything in place, and as soon as we get that mandate, we'll get it on the docket.
Sounds good, Your Honor.
Okay. That would be the order of the court. Thank you all for your time and your service, and I'll see some of you after lunch. All parties outside of Perk County, are there any objections?
No objection.
No.
No objection, Your Honor.
All right. Ms. Moore, can you go ahead and state your name, please?
Jordan Moore, mother of the children.
Thank you. All right, Ms. Tyler Green, you may go ahead.
Emily Kyler Green, attorney for the department.
Blaine Minen, permanency specialist with Belong.
Ashley Crouch, permanency supervisor with Belong.
Maureen Yanis, attorney for the mother, Jordan Moore.
Deborah Fuller, attorney for the father, Adiel Carrizales. Mr. Carrizales, can you announce, please?
Yeah, Carrizales' father.
Jennifer Harris, attorney for respondent father. He's not present. I'm ready.
Richard Sullivan, attorney for the children, ready?
Amy Harding, Hill Country Casa supervisor.
Kimmy Martin, Casa for the children.
Mr. Minen, I've been able to review your report. There's no Indian child heritage in this case, correct?
No, sir.
All right, and permanency goal this time is family reunification?
Yes, sir.
The children are still in their kinship placement in Kerr County?
Yes, sir, they are.
And that placement is safe and appropriate, meeting their needs?
Yes, sir.
Is it in their best interest to continue in that placement?
Yes, sir.
All right. Are there any issues with placement at this time that we need to discuss?
With the placement, no, sir.
Okay. My reports show that the children are up to date on all their checkups. They're just having to deal with some issues here and there. Is that the case?
Yes, sir.
Anything that we need to discuss today or any orders that are needed as far as their mental or emotional or physical health?
Not right now.
And none of them are receiving psychotropics, correct?
So Aiden had previously received a psychotropic medication. On September 30th, Ms. Fuller made us aware that Aiden had been prescribed that psychotropic medication for ADHD, which was 2 milligrams a day of guanfacine. It was started without Belong's knowledge or without Mr. Carzales's consent. We asked for a follow-up appointment to be made with Aiden's pediatrician, Dr. Merriweather, who prescribed the medication, as well as for both parents to attend and receive weaning instructions if both parents did not consent. The appointment for that was held on October 9th. Mr. Carzales was in attendance and Ms. Moore was not in attendance. Dr. Merriweather did not provide the weaning instructions at the time of the appointment, but we were able to reach out to him later that same day and obtain the weaning instructions, which were that Aiden could stop the medication due to the low dose. We provided those instructions to placement, and Mr. Carzales did request a second opinion from a different pediatrician, Dr. Delaney, but Dr. Delaney's office was not taking new patients. And Mr. Carzales has not provided the name of another pediatrician for a second opinion yet. But besides that, that was the only issue with psychotropic medication for the children.
Okay. But he's off of it now?
Yes, sir.
Okay. I just want to make sure that I wasn't misunderstanding you. And it was such a low dose that he didn't need to be weaned off. That's what you said?
Correct.
Okay. All right. Are all of the school-age children's educational needs being met?
So going back to Aiden for that, the rest of Jackson is the only other child school aged, but Aiden is having difficulties at school. He hasn't been able to complete his weekly workbooks during the school year and is struggling to remain on task. He's been having a lot of trouble focusing in class and controlling his behaviors, crawling around on the floor and just kind of being out of control in the classroom. He's testing below average, which is concerning because the first half of first grade is a review on what you learned in kindergarten. So he doesn't have the base knowledge to build upon the new information the rest of the school year. And he is at risk of having to repeat the first grade. Aiden does receive reading recovery services 4 days per week for 30 minutes as an automatic support. His teacher has tried various seating arrangements, proximity while teaching, and extending time for Aiden to complete his assignments, as well as engaging in individual instruction with him. I've been in contact with Aiden's assistant principal at Tom Daniels, and she informed me that Aiden's ARD took place on October 28th, and they got the signatures for the 504 accommodations on November 11th. So Aiden has had 504 accommodations since November 11th. She informed me that most of the accommodations that they can use for first graders were what Aiden's teacher was already doing with him in the classroom. So they couldn't really add more support to that. And she also stated that since the ARD's been in place and since Aiden's teacher has been providing those accommodations to Aiden, that there's been little to no improvement in Aiden's behaviors at school.
Do you think that there are any further orders that we could put in place at this time that would assist in that process? Or do you think that it's just something we're going to have to continue to try to get through?
I think there are orders that could be put in place. Aiden's therapist recommended that 504 services be started before trying him on medication to help with his behaviors and help with his learning at school. So I think the next step, medication, would probably have to be it, given that he is not improving at school and he has had most of the accommodations that he's received in his 504 since the beginning of the year, and there still hasn't been improvement.
Okay. And you said the ARD's not, what's the ARD? There was an ARD in October?
October 28th is what the school told me.
So he won't be due for another one for quite some time?
That's my understanding, yes.
Unless I order one.
I believe so.
It's kind of getting to that gray area, but okay. let's talk about the parents. It appears from what I'm reading that they're in compliance still. They were in compliance in September. Looks like they still are. Is that correct?
So both parents right now are not in compliance. They're close to being in compliance. They just both have things that they need to engage in and address before being in compliance. Due to the parents' previous compliance with the family plan, we haven't changed the permanency goal or anything like that. But as far as compliance for Miss Moore, she needs to engage in her domestic violence support group that she was sent information for, as well as start family counseling with her children and keeping appointments with her therapist, Joni Chavez Martel.
Has that become a problem since September?
Yes, Miss Moore has missed 2 consecutive appointments with Miss Chavez. Miss Moore did inform me today, however, that she is scheduled for an appointment with Miss Chavez on December 13th. So she hasn't been dropped, but she has been missing appointments.
What was the given reason for missing the appointments?
When I talked to Miss Moore, she said that one of the days she was working and had forgot that she had her appointment with Joni and had offered to stay late to help at work. But I'm not sure about the first reason.
What other concerns do you have as far as her compliance?
Can you repeat that? It was kind of breaking up a little bit.
What other concerns do you have as far as Miss Moore's compliance?
So for Miss Moore, the only other thing I have is we provided information for a co-parenting class, which actually both parents were not engaging in. And we did send her information for an additional co-parenting class, but she has started that now. So that's in place, but there was pushback to starting that.
Which course was that?
Can you repeat that?
Which course?
That co-parenting course is the
That's what I was doing. I couldn't remember if you said parenting or co-parenting. Okay. What about Mr. Canisales? Why you said that neither parent is in compliance at this point in time? What are the reasons he is not considered to be in compliance by the law?
So Mr. Carizales did not complete his OSAR evaluation and was reminded several times to reschedule that. It got to the point where he wasn't able to reschedule it himself because he had waited too long. I did speak to OSAR and we were able to get him another OSAR evaluation set up for December 17th at noon. So Mr. Carizales still needs to complete an OSAR evaluation as well as engage in random drug testing. Mr. Carizales has been provided with information for a parenting class with the Parent Resource Center in Kerrville, as recommended from his psychological. And we're in agreement with CASA's report and recommending anger management and or BIP due to the ongoing issues with Mr. Carizales' ex-girlfriend. We received a police report from September 30th that he and—
Your Honor, I'd object to him testifying about a police report based on he does not have personal knowledge of what happened on September 30th.
Your Honor, I don't know if the objection is hearsay or lack of personal knowledge. He's using this information from the police report in recommending further services, as well as the services that have been recommended by the I believe by his therapist. So this is what Belong has to utilize in order to recommend services and to see whether or not the court's going to grant them.
Mr. Fuller, you can take him on board IR as far as whether or not how he got the information and where it came from.
Mr. Minan?
Yes.
How long have you been a caseworker for the Carizales case?
I have been a caseworker since the start of the case.
Okay. And when did you obtain a police report that you're referring to?
I believe it was sent out on Monday of this week.
So December 2nd?
Yes, ma'am.
Were you informed at any other time in regards to any incidents by Ms. Moore in regards to domestic violence?
Can you repeat that?
This police report that you're referring to, you're using that to request additional services from Mr. Carrizales?
Yes, so I'm using that to say that we're in agreement with CASA's recommendation that he engage in anger management classes due to him already addressing anger management in therapy and that not showing much change yet.
Do you have personal knowledge about the incident that occurred on September 30th?
I have the police report for that.
Have you discussed the police report with Mr. Carrizales?
Yes, I have.
Have you discussed it with the alleged victim on the report?
No, I have not.
Okay. Have you spoke to any police officers in regards to the report?
Not directly, no.
Your Honor, I would request that any testimony about the incident in regards to specifics be not allowed to be put forth in front of the court. We don't have certified copies of the police report. And I feel that it would be inappropriate for it to be brought forward today.
I think what I'm going to do is sustain. I'm assuming you're making a hearsay objection, correct? I didn't hear it on the record.
Yeah.
Okay.
Yes, Your Honor.
I'm going to partially sustain the hearsay objection as to getting into specific acts, allegations, or omissions, but I'm going to allow the testimony as it pertains to concerns. I do believe that Mr. Minen is he's a custodian of the records, and it's from a source that the court finds trustworthy. It's the police department as far as the record itself, but we will avoid getting into specifics in there. So, Mr. Minen, your testimony is that based on this police report, you have concerns.
Yes, sir.
And those concerns have belong to, and apparently CASA, from what you said, to believe that recommendations for anger management or BIP are necessary.
Yes, sir.
Do you need to get into any more of the information in that report in order for the court to know what it is you want?
I don't believe so.
Okay.
Unless anybody else needed more information about it.
Well, I mean, if the point of introducing that evidence is for the court to believe that there may be an issue with anger management or domestic violence and a BIP may be necessary, you've gotten that in on the record. So unless somebody else wants to ask questions about it, we can move on.
Okay.
You were testifying as to that particular aspect of it and then started to get into the specifics of the report when Ms. Fuller objected. Is there anything else that he needs to do outside of that would put him into compliance?
So, kind of like I addressed earlier, Mr. Carrizales had not engaged in the original co-parenting class he was sent. And there was, like I said, pushback on that. But Mr. Carrizales was provided with the same information for the co-parenting class that Ms. Moore was. And I spoke to Mr. Carrizales, and he is engaging in that class. So he will need to continue to engage in that. One other thing for both parents is that both of their therapists have recommended that communication between them go through the Family Wizard app, and that has not been set up yet.
You believe this case is appropriate for mediation?
I believe it could be, yes, sir.
Now, Mr. Mendez is not here. He was not here last time. Have you heard from him? What sort of contact have you had with him? And is he in compliance or not?
Mr. Mendez is not in compliance and has not been in communication with me. He's voiced to his attorney that he intends on signing a relinquishment of his parental rights. And after that has not been in any sort of communication.
Okay. What happened? My notes from September suggested to me, or at least at that day, parents were in compliance. It seemed like we were on the right track. So is there any specific thing that might have happened that had changed thing or that has changed things in the last couple months? Are you aware of anything else?
So the biggest thing I'd say was Aiden being started on psychotropic medication without Mr. Carrizales's consent. I think that kind of threw everything in the wrong direction a little bit, which led to more butting heads and bickering and not being able to co-parent correctly, which kept leading to more arguments. And I think that inability to, with the parents to communicate with each other has taken a little bit of a detriment to this case, which is why I feel like the co-parenting is one of the most important things to address for these parents. I can say lately, communication has not gone through the Family Wizard app, and instead parents communicate in a group chat with me and placement about visitation and how the kids are doing. Both placement, Mr. Carrizales and Miss Moore have been combative with each other in that group message, but as of late, things have calmed down a little bit more and both parents are starting to co-parent more. So I hope we're getting back on the right track, but I believe that moment that may have caused things to go a little off the rails was Aiden being started on medication.
And Aiden started on the medication based on the diagnosis and prescription of a doctor, correct?
Can you repeat that? Sorry, it cut out again.
Aiden was started on the medication based on a physician's recommendation and diagnosis, correct?
Yes, sir.
So it's not safe to return the children to any parent today from your testimony?
No, sir.
And the parents have not addressed all the concerns at this time?
No, sir.
And it's safe, it's in the best interest of the children to remain in the temporary managing conservatorship of the department / belong?
Yes, sir.
All right, Ms. Kyler Green, questions for Mr. Minum?
Yes, Your Honor, thank you. Is either parent contributing any child support or support in kind to the children or to the placement?
Miss Moore, I know, goes over and helps cook dinner and helps the kids get ready for bed. I know Mr. Carrizales had taken the children to get shoes the other day from some sort of church drive. But other than that, I'm not sure what the parents would be contributing in terms of that.
Okay, would you like to see more being contributed from Mr. Carrizales?
Yes.
Okay, and how would you like to see that done? Just through money being provided or services and clothes and stuff like that for the children?
I think this would be a good opportunity for Mr. Carrizales to reach out to the placement and see what the children need on a daily basis and improve that communication in that to address whatever needs the children have right now.
Okay. Was there a time recently when someone from Belong was trying to visit with Mr. Carrizales to discuss his current status with this case?
Yes, me and Miss Martin visited Mr. Carrizales at his parents' house.
And when was this?
This was on November, I believe it was November 21st, yes.
Okay, and did anything of importance happen at this visit that you think is appropriate to share with the court?
While me and Miss Martin were meeting with Mr. Carrizales, we were discussing why Mr. Carrizales had missed a visit with his children after the schedule for the visits was put in place. And Mr. Carrizales got defensive when talking with Miss Martin about the reason for the missed visit and informed us that it was private property and that we needed to leave.
Were you able to finish talking to him about everything that you needed to discuss in regard to the case, or were you kicked out before you were able to complete your meeting with him?
We were asked to leave before we were able to complete that meeting.
Okay. Can you describe this a little bit? Was it aggressive? Was it kind? Like what was the tenor of this interaction?
Mr. Carrizales got very defensive when asked about why he had not visited with his children. He talked a lot in more of an aggressive manner. It was, like I said, very defensive, not wanting to take ownership of the events that occurred.
Okay, and are there also concerns with Mr. Carrizales not being truthful about his relationship with a prior girlfriend or current girlfriend?
There are.
Okay, and why do you have concerns about his ability to be truthful about that relationship?
There have been police reports throughout the time that Mr. Carrizales and an ex-girlfriend were together, which did lead to a removal of children in a separate CPS case. The children in this case have been they've been witness to Mr. Carrizales being in arguments and
Your Honor,
fights.
I would object to Mr. Minen testifying to what the children witnessed unless he was a part of that previous case that he's referring to.
And Your Honor, I don't even need him to go into the specifics of this. My question, I could just rephrase the question to narrow it a little bit. Okay, so you stated that you had concerns about Mr. Carrizales lying about a relationship. Does that impact the safety or best interest of the children, in your opinion?
Yes, I believe it does.
Okay. We've talked a lot throughout your testimony about the parents' ability to co-parent together for the best, just for the best interest of their children. Is that the prominent concern that you have in this case?
Yes, it is.
Okay. And to your understanding, will anger management and BIP that have been requested, will those help facilitate better co-parenting as well?
I believe so.
Okay. And can you be specific as to what is Belong's position regarding the psychotropic medications for Aiden?
Due to the interventions that haven't worked for Aiden, I believe that it would be appropriate to try him on medication, which was recommended by his therapist, if the 504 accommodations were to not work. So I would be in favor of that.
Okay. Your Honor, I think that's all the questions I have. Thank you.
I understand that there's going to be more questions. I just want to make sure everybody understands it's 2 o'clock, 2:03. So I'm going to allow all the attorneys to ask the questions that you need to ask. Just please be as brief as you can be. I want you to get your evidence in, but let's stay on point, please, so that we can finish at a decent hour here. Miss Giannis, questions?
I'll try to be brief, Judge. Yes, thank you. You testified that mom needs to engage in individual counseling and a co-parenting class, yet you testified also that she's starting back with Joni next week and she is engaged in her co-parenting class. Is that correct?
Yes.
So would you say that she's on track to get back into compliance?
I would say so, yes.
Okay. And isn't it true that mom goes over and makes lunches for these kids? She buys groceries for the grandparents. She goes and does laundry. And she does way more to help the placement out than just helping the kids bathe and do homework.
Yes, I can't testify to whether or not she purchases groceries for them, but she does go help out and do everything else.
Okay. And as far as co-parenting goes, was that on the parents' original family plan of service?
No, but it was recommended by their therapist.
Okay, but what good does it do for one parent to complete co-parenting and the other not?
Both parents were sent the information to complete the co-parenting class, as both parents were recommended by each of their own therapists too.
I understand. And so mom is engaged and she's probably going to finish co-parenting. But what good is that going to do if dad doesn't engage?
I actually did talk to Mr. Carrizales about that today, and he informed me that he has been through, I believe he mentioned 2 modules of the 8 that are included in the online class. So he is currently working through that.
Okay, thank you. And isn't it true that mom is having a hard time getting through to K-Star to start family therapy?
That's my understanding, yes.
Thank you. I'll pass.
Did you say Ms. Fuller?
Ms. Harris.
Oh, Ms. Harris.
Have you been in contact with Mr. Mendez?
I have not.
Is it your understanding that he intends to sign a relinquishment?
Yes, ma'am.
And that's for Genesis, correct?
Yes, ma'am.
Does he have any relationship with Genesis?
Not to my knowledge.
No further questions, Judge.
Ms. Fuller.
Mr. Minen, in regards to Mr. Carrizales, has it been difficult for him to communicate with the placement?
It has, yes.
And has he attempted to communicate with the mother, but has been told by the placement that he needs to talk to her and not the mother?
Yes.
And in regards to the co-parenting, if the goal is reunification, how important is it that Ms. Moore and Mr. Carrizales be able to communicate without the interference of the placement?
Very important.
And have you been able to meet with the placement and Mr. Carrizales and Ms. Moore and discuss that they need to all be working together, and mom and dad specifically, so they can co-parent?
I haven't had a meeting with all of them together at the same time, but I have communicated those. I have informed placement, mom and dad, that co-parenting and communication is going to be very important and is in the best interest of the children moving forward during and after the case.
And it was your statement that you had a group chat, but that wasn't going very well initially. Do you feel like it's getting better?
Yes, since Thanksgiving, communication on that group chat has improved a lot more. And that's something I also talked to Adial about earlier today. He feels like it's improving too. So I think the group chat right now is headed in the right direction.
So do you still feel that the family wizard is necessary, since Miss Moore doesn't have the children? So the communication between Adiala and Jordan is pretty limited anyway, since she does not have the children.
I believe the family wizard is important to start for when Belong and everyone else is out of this case. I think getting that habit set up now would set up the parents to be successful for when reunification is achieved.
Okay, and both parents have been provided that information?
Yes.
Okay, in regards to the anger management in the BIP, have you talked to Mr. Loop about the necessity of adding more services for Mr. Carrizales?
I have not spoken to Mr. Loop about that yet, no.
Because Mr. Loop is the one providing therapy and anger management, correct?
Correct.
Okay, do you think it would be important to speak to him as well to see if there's other services that he can provide, since he has a relationship with my client already?
Yes, I can reach out to him about that.
Okay. And then in regards to the OSAR, there was issues setting it up originally. My client did not set it up, and so then he wasn't able to, correct? It had to go back through you?
So I submitted the referral for his OSAR back in August, I believe, and it was scheduled for September 9th. When Mr. Carrizales missed that appointment, I sent the number to him that was provided to me so that he could schedule an OSAR.
My question was, when he missed it, was it the only way he could get it set up again was through you setting it up, or you contacting them and doing a re-referral for the OSAR?
So after he missed it originally, he was going to be able to set it up by himself by talking to OSAR and setting a time and date that worked for him. And by the time that he did call the OSAR people back, it had been too long. So I sent in another referral and talked to them. So we did get it rescheduled.
And the reason that he has to do the OSAR is because of a positive marijuana test. Is that what that is?
Yes, from the start of the case.
And that was from when?
Let me pull up the date from my report for you real quick. He tested positive on June 17th.
Has he had any other positive tests?
Not since then, no.
And has there been any other concerns besides marijuana use with my client?
Not at this time, no.
In regards to the issue that you said led to some discontent during this case, is it your statement today that you were not made aware that Aiden was placed on psychotropic meds?
Correct.
So how did this happen?
That Aiden was put on meds?
Yes, without Belong's involvement.
So it's my understanding that due to the recommendations that were made in Aiden's psychological and cans, that he have an appointment to discuss possibly getting on ADHD medication, and that was set up, and that placement was not aware that there had to be notification or consent from both parents for that medication.
And who was involved in that decision and helping set up that appointment?
Your Honor, I want to object to this line of questioning because I think Ms. Fuller is going into specifics of, I guess, specifics of the background of how the psychotropic medications were starting to be prescribed for Aiden. And I think that this should be in the form of a motion that has not been filed yet. And for the court's efficiency, I don't think we should go down this road.
Well, I'm aware that this happened, and I'm aware of why, for the most part. But I agree, we're not set for a hearing that's going to take us down the road of that particular issue. So I'm aware of it. I know it happened. Ms. Fuller, if you feel like it needs to be addressed further, then I don't have any issue putting a motion on the docket if you want to get into that. But as for right now, I think I've heard what I need to hear today. We need to move on.
Well, Your Honor, since I will be asking that the CASA volunteer be removed from this case due to a conflict, I would like the testimony to be put on the record.
I think that's going to require a formal motion and a formal setting, because we're not set for it today. Nobody's got any notice of it, and we don't have the time. I've got a waiting room full of people waiting on the next case that was supposed to begin 14 minutes ago. So get with Ms. Greenlee, file a motion, and we'll set it, and I'll hear what you want me to hear.
In regards to Mr. Carrizales, do you feel that he completely understands what he needs to do going forward?
I believe so, yes.
And when are you willing to encourage the placement to have better communication with Mr. Carrizales?
Absolutely.
And do you have any concerns about his visitation with his children?
Right now, I do not know.
And in regards to Mr. Carrizales and the medication issue, did he in fact want alternatives to be tried prior to medication?
Yes, he did.
And when you say the 504 was established and the interventions haven't worked, you said that wasn't done. The ARD wasn't implemented. The 504 wasn't implemented till November 11th. And then the kids were out of school for what, a week for Thanksgiving? So really it hasn't been implemented for very long, has it?
So when I talked to the assistant principal today, she did inform me that for first graders, they're not able to provide much more accommodations than what Aiden's teacher had been doing for him previously for the entire school year so far.
But Mr. Minen, you stated that on November 11th, the 504 accommodations were established. So your statement made it sound like they were doing additional services or providing additional services for Aiden.
Yes, so I did ask for the school to send me that paperwork, and they have not sent that to me yet. So I'm not sure about the specific accommodations that they're adding to what was already being done.
So do you think it's important to understand what accommodations and whether they're going to be effective before placing a 5-year-old on psychotropic meds?
I do think it's important, but like I said, the assistant principal made it pretty clear to me that not much had changed for Aiden's everyday classroom routine.
In regards to the involvement of the mother in services, at what point did she drop off to some degree?
I'm not sure about an exact date. I would have to go back and look to be more specific, but I would say it was also around when everything happened with Aiden being on medication.
And did you at any time inform the mother that it wasn't necessary for her to do any more services, that she was on track?
No, I provided Miss Moore with information for additional services that she would need to complete.
And are you aware that Mr. Carrizales has provided like sports equipment and things for the boys to play sports and other things to miss the placement?
I was not aware of that, no.
And do you feel it's necessary for him to provide you a list of what he's provided?
That would be beneficial, yes.
Okay. And you said you've been out to his home, and do you have any concerns whatsoever with the home?
No, I don't.
And in regards to that encounter on November 21st, the defensiveness of my client was basically due to questioning by the CASA volunteer, was it not?
Objection, speculation, Judge.
Sustained rephrase.
When Mr. Carrizales said to leave the property, Miss Martin was asking him questions, correct? And making
Objection,
statements.
relevancy, Judge, to this permanency hearing. And I don't think it's relevant to our hearing, Judge.
I would tend to agree. Where are we going with this, Ms. Floyd?
I'm concerned about the involvement of the CASA volunteer, Your Honor, and I can set it for a hearing. I'll get a hearing date for from Ms. Greenlee to ask for the removal of the CASA volunteer. But if the plan is reunification, I think that we need a team that is working for reunification.
All right. Well, you can definitely set that motion, but we need to move on now. We're at 20 after almost.
Has there been concerns expressed to you that the mother still has a relationship with Mr. Mendez?
There have been concerns, but that have been brought to me, but I haven't had any concerns myself.
Okay, and you haven't spoken to Mr. Mendez?
No, not since the beginning of the case.
And you haven't done any type of investigation to determine if it's in fact true?
In talking to Ms. Moore, she has stated that she has not had any communication with Mr. Mendez.
Okay. Has there also been concerns about the visitation schedule and Ms. Moore possibly staying overnight with the children?
Can you repeat that?
Has there also been concerns about the visitation schedule and Mrs. Moore possibly staying overnight with the children in violation of what the agreement was for extended visitation?
There have been concerns brought to me, yes, but I also do not have concerns about that.
And did you investigate that situation?
Yes, I talked to placement and Ms. Moore about that.
Okay, so asking the placement and the mother whether they're violating the agreement, you feel like that's an appropriate amount of investigation?
I also visited with Ms. Moore's grandparents where she does reside and have talked to them while she has not been present. And they have informed me that she's continued to stay with them and sleeps there at night.
Okay, I'll pass one.
Judge, I just reserved for closing, Judge.
Okay. Let me hear from the attorneys in order, and then I'll hear from the attorney ad litem and the guardian ad litem at the end of that order, and then give Ms. Skylar Green the opportunity to offer a rebuttal if there is any. Ms. Skylar Green, close.
Thank you, Your Honor. I think all the department is requesting today is for mediation to be ordered, for there to be, I guess, a move forward in getting Aiden back onto psychotropic medications. It's my understanding that he was doing better when he was on them, and there's concern that he will not pass the school year at the rate that he's going. And in regards to the services, obviously we're requesting that the parents continue to be, or ordered to continue to engage in the services that have been recommended by their therapists. And that's it, Your Honor. Thank you.
Thank you, Ms. Gallants.
Judge, I would just ask that you find that the mother is in compliance. If she were in full compliance, we wouldn't be here today. She's ongoing in services, and she should be not penalized for missing just a couple of therapy sessions when she is on track to re-engage.
Yeah, Mrs. Harris.
I don't have anything, Your Honor. My client intends to file a relinquishment with the court and ask that be accepted.
Do you have the contact information you need to get that accomplished with him?
Yes, Judge.
Okay. Ms. Fuller?
Well, Your Honor, I will be asking for a setting, but I am making the court aware that I feel there's an extreme conflict in this case with the CASA volunteer and Miss Moore. And I feel that it is to my client's detriment that that relationship. And I'm asking that the court take a serious look at this situation. My client has attempted to do the services and work his plan, and he has been let me think of the best way to phrase it. He's been prevented from having an appropriate relationship with his children because of the interactions or interventions of the placement and of the CASA volunteer. So I am very concerned about that. I'm asking that I get a setting with Miss Greenlee so everybody is aware of it and that we go forward on that. I think mediation is necessary, but I also feel that the placement needs to communicate better with my client and allow him to have his visitation, not to prevent him in any way from seeing his children. And they need to work together to see if this situation will work out for reunification. That's still the plan, but I think there's been some obstacles that shouldn't have had to happen.
Your Honor, the children are doing well overall. The main concern is with Aiden. Originally I found out that he was on medication, and of course we had several meetings about it. We try to put the 504 in place. I know it's been only a month, but after visiting with the home and seeing the teacher's notes, it doesn't seem like he's on track. We're in the middle of the school year. I don't want him to be delayed and have to do a whole year again. I do want to visit the medication issue if we have to have another hearing on it. We have a pediatrician that recommended it. Mr. Carrizales had the opportunity to have a second opinion because he was opposed on it. He never followed through with that. We have him, Aiden, putting holes in the wall at the house. We're having him fall behind on simple assignments. And so I think we really need to explore this medication to see if that'll help him and save this school year so he doesn't have to repeat again. Other than that, the other children are doing well. I do want to see Mr. Carrizales help more with the children as far as in-kind support. I'm getting reported that he's only provided some sports shoes. Now, if he can provide proof that he's given more, I'm willing to look at that, and he can give that to the department. From what I'm getting reported is that he's not helping very much in-kind support with the children. We got young children, they have a lot of needs, and so I'd like him to step up and assist. Ms. Moore is helping. She's going to the house. She's providing food, clothing, and those kind of things. So I believe that's appropriate right now, Judge. And so I just defer to the court on whether we can have a decision on the medication today or have to have a hearing on it. But it's something that needs to be heard pretty quickly, Judge.
Thank you. Ms. Martin.
Yes, Judge. I would disagree with Mr. Salvador. The kids are doing really, really well in the placement. The concern is with Aiden.
Okay. Thank you. Anything else that you want to add, Ms. Collery?
No, Your Honor. Thank you.
For the purposes of the permanency review before final order, the court finds there's no Indian child heritage in this case. Court finds that the permanency goal of family reunification is still appropriate at this time and in the best interest of the children. We're looking at a dismissal date on this case in May, so there is time for these things that we're concerned about to be addressed. And I think that maintaining that permanency goal of family reunification, we're still on a track to where that is appropriate. And find that the placement is safe and appropriate, meeting the needs of the children and in their best interest to continue. Find the children are up to date on their medical, dental, and vision checkups as appropriate, and that At this time, none of them are receiving psychotropic medication. We'll talk about Aiden's needs here in a minute. We'll find that the school-age children, their educational needs are being met as far as what they're being provided, but obviously we're not hitting the mark with Aiden, and that needs to be addressed, and I'll take that up in a minute. I'm going to find that Miss Moore is in minimal compliance at this time. That sounds bad, but you can't miss things, Miss Moore, and I know you know that. Right now, even if it seems like it might be a little bit unfair, you're under a very intense microscope. And there are a lot of people who've been in child welfare a long time who are looking very closely at everything you do and making sure that you have the ability to follow through on your commitments. Because if you can't follow through on these commitments, it throws into question your ability to parent the children when they're back in your home. The goal here is to get the children home with you. And I just need you to engage 100%. And if it means having a calendar, either whether it's on your phone or something you write down on, putting reminders so that you don't forget these things, then that's what you need to do. I use those things all the time. So they're very helpful, and that's how you avoid missing appointments. And nobody expects you to be perfect, but you're going to have to really step up your game so that you can get into full compliance here, as Ms. Yana suggested, and get to a point where I can say, okay, it's time for the children to go home. We're not there yet, but that's the goal. Going to find that Mr. Catasalis is not in compliance at this point. You're not far from it, Mr. Catasalis, but you've done some things that are concerning to me, and I'm going to talk about those in a minute. Just because I'm finding that you're not in compliance today, so it should not deter you or take away your motivation and your discipline to keep working in this case. It means that you have to figure out what we need to change, and I'm going to give you some suggestions and make some orders here in a moment. You both heard what it is that you need to be working on and what it is that you need to do. You heard Mr. Minen say it, and you're in constant contact with Mr. Minen. So there's no excuse for you to not know what it is you need to do. You have a family plan of service, and you have a caseworker who's maintaining contact with you on a regular basis. So the information is there for you. The court finds that Mr. Mendez is not in compliance and that his intention is to relinquish. If we get that done beforehand, that's something we can take up beforehand, or we can just save it till we get to a final. I am going to order the parties to mediation. And that needs to be completed prior to the final trial date. Our next hearing, which is the final trial date, is March 5th, 2025 at 9:30. March 5th, 2025 at 9:30. I'm going to order the parents to use Family Wizard to communicate. And I'm familiar with our Family Wizard. I used it when I practiced and represented people in CPS cases and divorce cases and custody cases. It's there as a tool to not only protect the conversations between the two of you, but they're recorded and they're admissible in court, unlike text messages like you'll find in a group chat or emails, which have to be proved up. Court orders our Family Wizard. Those conversations between the two of you there's a record of it, and all we have to do is get it from them, and it's admissible in court. And then everybody can see what's going on between the two of you as far as your co-parenting goes. That's important in this case. And I've heard a lot of people say the word co-parenting in this case, just in this hearing. So obviously we need to use that tool. So I'm ordering that as far as communicating about the children that are under the jurisdiction of this court, you're going to communicate through our Family Wizard. No more texting about the kids. No more calls or emails about the children and co-parenting. Whatever else you talk about, that's not subject to my order. This involves the children. So if you're talking about the kids, you need to be doing it on our Family Wizard, because Mr. Mine is exactly right. When we're all out of this case, that's how you're going to communicate. And that's what's going to keep these issues from blowing up. Because you both know that anybody can read what you're texting. And you both know that it's admissible in court and that you're accountable for what you're saying. And that was a therapist that recommended that you use that. I'm ordering you to use it based on that therapist recommendation. I'm also going to order that Mr. Cadizales start either an anger management or a BIP class as soon as possible. So Mr. Minor, please help him figure out what it is he needs to do and where he can go and what's available. And we need to get that done. Court finds it's not safe to return the children to either any parent today. They haven't addressed all the concerns. And it's the best interest of the children to remain in temporary managed conservatorship of the department or belong. As far as the in-kind child support, based on all the testimony I heard, it sounds like mom is really putting in a valiant effort to help with placement, and she's working. She's at work right now during this hearing. I think that that's probably the best that she can do right now, but it wouldn't hurt Miss Moore to buy some things for the placement that you can afford. It sounds like Mr. Cadizales, I heard testimony that he at some point was going to get some shoes through Church Drive and then not much else. So Mr. Cadizales, you need to step it up. This court could order child support. I haven't done that because I want to see how you all can work together to provide for your children voluntarily. One concern I have is this medication with Aiden. We've got a child who's being defiant. We've got a child who is getting behind in school. We have a therapist and a physician, both professionals, who recommended a low dose of a medication. I completely understand and appreciate that the parents have the right to consent or not consent to that. I respect that. That's a very important right to have. But we can't ignore the fact that the 504 combinations that have been put in place are not working. And when we have a child who's in school getting behind a 6-year-old, one semester of school is a really long time for a 6-year-old. That's a really big portion of their life. So I'm going to make an order today that, because we don't have a second opinion, because you didn't follow through with it, Mr. Cadizales, whatever the medical professional recommended, whatever the therapist recommended, that needs to be done. So if there was a diagnosis and a prescription for a low dosage of medication that showed to help this child, then that's the court's order, is that prescription be followed. We're not going to take the decision-making authority of someone who has medical knowledge and medical expertise that none of us have out of their hands at the expense of a child. If we had another option, then I would definitely entertain that, but we don't, and time's running out. So that's the order there. That medication, if the doctor says he needs to get back on it, then that's what we're going to do. I'm also concerned about this November 21st visit. I'm hearing two different sides of it. I have a feeling I'm going to hear a lot more of it, but this is what I want to say about that. If we're over halfway through a case, Mr. Cadizales, and we're getting to a point, whatever the cause is, whatever the precipitating event or conversation was, if we're over halfway through a case and we're kicking your caseworker and the CASA worker who are there to help reunify your family and try to get you the services you need, if you're kicking them off your property, something's not right. We're headed in the wrong direction. And that is not going to work out for you. I want to make sure you understand what I'm saying. That approach is not going to work for you. It's not going to work. So that's why you definitely need to be in anger management or BIP, so that you can take a look at yourself, and you need to engage in that and determine if you can laugh at me, you can smile, but it's not going to change the court's order, and it's not going to change what you need to do. If you don't do these things and you don't show that you recognize that you have some things that you need to work on, there's going to come a day where you're not going to be laughing. You're not going to be smiling, and you're not going to have any reason to kick anybody out of your house, because nobody's going to be working with you anymore. I don't want to see that happen to you. I want to see you get to a point where you realize you and Miss Moore need help, and you need to engage in it timely, and you need to follow up with it. because there's nobody in the world that's immune from bettering themselves. We all can in some way. We all have something we can work on, and that's something you need to work on. Our next hearing, as I said, is our final trial, March 5th, 2025 at 9:30. So mediate before then. I think I've been very clear on my concerns and the orders of the court. Ms. Moore and Mr. Cadizales, Mr. Mendez has decided he doesn't want to be involved in this anymore. So it's up to the two of you. Mr. Cadizales, if you want to co-parent with Ms. Moore, you have to understand you're going to be co-parenting with 3 children, not just 2, because Mr. Mendez is not going to be there. You're not going to have the same rights to that child as you do yours, but
He has 3 children, Your Honor.
I'm sorry, did I get it backwards?
He has 3. The 4th child was Mr.
The 4th,
Mendez.
I'm sorry. You've got to make sure that you realize that that child is your child too for purposes of co-parenting. Because if Ms. Moore gets all 4 kids back, they're all 4 going to be close. They're going to be siblings. They're going to be involved with each other. And you're going to have to step up for that child too, if you want to co-parent with her. And you're not going to get there by being combative or defiant. It's not going to happen. So I'm urging you both to engage. I'm urging you both to work really hard. I don't want to sound preachy, but I'm telling you what you need to know. I'm telling you what I tell every other parent in these cases. And the ones who listen and the ones who do it, and they rely on all the people in this courtroom, and they get the services and the help they need, and they admit where they're wrong, and they fix the problems that are shown to them, they're usually successful. But the other part of that is that there's not a lot of them who do that. The statistics are that most people aren't going to do that. And you get to choose on which statistic you want to be. Ms. Kyler Green, is there anything I failed to address?
Your Honor, just a request that you reiterate the order for co-parenting for both parents.
It's ordered and it needs to be done. And that's a co-parenting class is just a small part of what co-parenting actually looks like. And you're going to learn that there. You're going to learn how to build each other up, and you're going to learn how to do the things that need to be done so that you're not fighting in front of the kids. That negative energy is not affecting them. That negative communication is not affecting them. And it's easier said than done, but it can be done. Anything else?
No, Your Honor. Thank you.
Okay. Thank you all for your time and your service. Good luck to you, parents, and if nothing further, all parties are excused.
No objection.
Okay. Ms. Skinner, can you raise your right hand, please? Do you swear or affirm that you will translate from English to Spanish to English to the best of your ability?
I do.
All right, thank you. I'm going to mute you now. Ms. Kyler Green, would you please begin the announcements?
Yes, good afternoon. Emily Kyler Green, attorney for the department.
Kim Coffey, Belonga Adoption Specialist.
Laura Martinez, Adoption Supervisor. Anna Swallow, Attorney ad litem for the children.
Amy Harding, Hill Country CASA Supervisor.
Janet Field Times, CASA, Guardian ad litem for the children.
Is there anyone else that needs to announce?
Jolly Cruz, I'm the local adoption worker that I see the kids every month.
Maria Garza, the kinship worker for Miss Puente.
Well, we were here on September the 4th for our permanency review of the final order. We had some issues that we needed to wait or to work our way through, some concerns. I ordered a progress hearing set for today because our next hearing wasn't until February. So that being the case, Ms. Coffey, where do we stand with some of the issues that we had back in September that we needed to follow up on?
Yes, Judge. So as far as like the medical kid issues with the kids, Edwin needed to see an ENT as well as an ophthalmologist or optometrist, which he has seen. He has his glasses. There's nothing seriously wrong as far as his ear, nose, and throat. I think he just has allergies. I think today the main concerns that need to be discussed further is that the therapy we had thought was set up in October with the therapist, because it took quite a while to find a therapist that could do bilingual therapy as well. The therapist was not responding to me at all, or Miss Puente, from my understanding. And I found out today that she was actually on leave because she had surgery. which I did speak with her today. She's basically, the kids had not started therapy with her. She is calling Miss Puente to set up for Friday or Saturday. So it's in the works now. I think there's just frustration of not knowing, as we were not getting any response from her. However, the kids are seeing two other people that they are seeing weekly. One is a behavior support specialist, another is a qualified mental health professional that they do see and they're able to talk to, that's addressing the loss of their mother, just not a licensed therapist. So that's one concern. I think mostly with Edwin because he is very depressed. And then another issue is with Edwin as well, is just his grades. He is failing 3 classes, basically due to not turning in school assignments. He's not uploading them to the online learning system that they have. Miss Puente, as well as her daughters, they are constantly reminding him. The teachers are constantly reminding him, trying to get him to come to tutorials. So we just need to figure out a way that we can get him to turn in these assignments, and also addressing his mental health to see if there's any other things that we can support them with.
Okay. Did grandparents get licensed with Arrow?
Not yet. I believe they have 3 more trainings that they're working on. Mr. Puente was working out of the state. He is now working in Dallas, so he's closer, which is good. Hoping not too much longer. There is some barriers with a few of the trainings that are only in English. I do believe Miss Garza will be helping the family, since she is bilingual, get through those trainings. So we're getting closer.
Okay. What are we doing? Any updates on the phone calls the children were having?
They are not communicating at all with their father.
Okay. And then there were education evaluations and then the extracurricular activities. That was something else we were going to discuss. Are there any follow-up on that?
Yes, Judge. Kevin and Edwin have had ARDs. They are receiving 504 accommodations. Leslie is being monitored to see if she would need extra accommodations. She is in a bilingual program at school. So that has been addressed. The teachers are very communicative with us through email and keep us updated. And then as far as, I'm sorry, what was the other thing that we were?
Extracurricular activities?
Oh, yes. So Edwin was the only one that was, it seemed, interested in joining the band. Shortly after the last court hearing, the next week, he was able to join band. So he is in the band, which he is very happy about.
Good. All right. Anything else that you needed to report today for the progress hearing?
Not that I can think of.
Do you believe that we need any other orders today, or do you believe that everything's going as well as it can go?
Well, now that I've spoken with the therapist, I don't know what more we could order in that area.
Is the therapist aware of the urgency?
Yes, when I spoke with her today, I stressed we are extremely concerned about Edwin's mental health and his depression, as well as his grades, that he needs to be talking to somebody like yesterday. So she is aware of the urgency, and she said she was going to call Mrs. Puente today and get scheduled to go to the home either Friday or Saturday.
Okay. And if they don't have something Friday or Saturday, you're going to blow up her phone?
Yes, Judge, I will.
All right, Ms. Kyler Green, do you have any questions for Ms. Coffey?
Just one, any issues with the placement signing releases, or the parents, or excuse me, the whoever needs to sign releases for the therapist?
So I think Ms. Garza was going to get Ms. Puente to sign a release, possibly for Giovanni. He is the one that comes out every week as well. I did speak with him, and he said one needed to be signed. And I think there was some communication that they were going to get her to sign that. He did talk with me a little bit, but he needed to speak with his supervisor before he could talk anymore with me. And I did let the therapist know that if she needs a release after, talking with me further, getting therapy notes, to please take that to this first session so that she could have Ms. Puente sign that release.
Okay, thank you. Nothing further, Your Honor.
Swallow.
Thank you. Ms. Coffey, so the therapist that you spoke to that is going to start hopefully within the next few days, that's in addition to the individuals that are coming out through My Center for Change.
That is correct. One is through the same center and another one is through Arrow, the licensing agency. They referred Miss Judkins to also work with the children. Even though they're not licensed yet, they are providing extra support.
Okay. Is anyone speaking with Leslie about anything?
At this time, no. I believe that she will also be with Miss Wheeler, who is the primary therapist.
Okay. Do you think some sort of meeting with the school is warranted? Or I guess, what are your thoughts on how we can support and help Edwin at this point?
I mean, I can have my own opinions on maybe why he's not turning in assignments. I do think he's very depressed and he probably doesn't really care at this point. I think we could have a meeting with the school to kind of talk about his mental health. I'm just not sure how much we can talk with them. You know, as far as what they're privy to, everybody's reminding him to assist with turning in assignments. I'm not sure much more what we can do. He does, the only tablet he has is the one that is issued by the school. And what he'll do is he'll get on there and watch videos, and there are a lot of things that are blocked on there, but I think he can still access videos. I did suggest to Ms. Garza to relay to Ms. Puente that he may need a little bit more hand-holding sitting at the dining room table and somebody sitting with him to ensure that he is getting these assignments done and uploaded.
Do we have any, do you have any indication, excuse me, on what his grades were like prior to basically his whole world falling apart?
I think he was doing well. He had, you know, passing grades. He was not failing anything. He is doing well in his other subjects. It's just those three that are pretty low.
I mean, for example, he has a 14 in science.
Correct. Science, math, and ELA are not good.
Okay, so I mean, I don't know what exactly the court can order us to do, possibly hold meetings, maybe bi-weekly meetings, something to where we all keep our finger on the pulse here, and we need to find a tutor. We need to find someone, would you agree with me, that can directly assist Edwin in getting his work done?
I think, yes, I do think tutoring is definitely something that is needed. I don't know if somebody can go to the home after school to assist. I don't know if they have the means that he could stay after school, if he could get a ride home. I'm not sure.
Okay, thank you. I pass the witness.
Anything else with trial hearings?
No, sir. Thank you.
Okay. And Ms. Swallow, anything else from you?
Just a report, Judge.
Go ahead.
I have serious concerns for Edwin. When I speak to him, he goes flat at times. He he answers my questions when I push, but he's just really not interested. And you know, it's different versus when I talk to him virtually, you know, it's one way. When I see him in person, he's a little more talkative and outgoing. But I mean, he has a 14 in science, a 21 in math. It's just, and it's due to a lot of missing assignments. Once a child gets, and Judge, you're fully aware of this, like once a child gets that far behind, it almost feels impossible for them to get caught up. So I feel like, you know, reminding him to do his assignments is possibly not helping. It's not helping. I feel like we need to figure out a plan on how we can support him in order to dig himself out of this hole. I think that's coupled with depression as well. So we need to figure out how we can support him better. Right now, I feel like we are, you know, his whole world has failed him, and we're the only ones that he has to help him.
Your Honor, do you mind if I just pause everyone for just 1 second?
Sure.
Thank you.
Did we lose her?
We in fact did.
That's all I had.
If we can get her back. I know Miss Garza can translate, but then it won't be official course, this is,
The interpreter just called Miss Puente.
Okay.
She's talking to her.
can the interpreter hear me? Well, I mean, I really only have one order to make. Did you want to weigh in on this at all? Who's it there? Miss Harding? Who's that with you? Miss Fieldheims?
Yes, Ms. Hines does have some things that she'd like to bring to your attention, Your Honor, if she may.
I do have information on his grades. When he was in Kerrville, science was 83, math was 75, English was 71, and he was in the Horizons classes, which equaled the honors classes. So he was doing pretty well. I saw him on Friday, Your Honor, and it just broke my heart and scared me to death. He is sinking. Edwin asked me a while ago if I could find out where on his mother's body the wound was, because his father's plane died, and he watches shows and knows, hit yourself in the head, maybe it was suicide. Not a head wound, and I think if he's told where the wound was, that it will help, because right now he's gone back onto his father's side, and he is sinking a lot faster and a lot worse than anybody can even imagine.
Thank you,
I don't know how to get this taken care of if there's no therapist.
Well, that's the issue. So, Miss Coffey, I'm going to order the parties to meet twice a month from here on out to discuss therapy, to make sure it's progressing. I don't want him just going. I want to make sure that he's engaging and he's getting something out of it, which is probably going to be tough to start out, but that's what it's going to take. His educational progress and any other needs that he has, because I can't agree with Miss Hildheims and Miss Swallow more, and I'm sure everybody else is probably on the same page. I think it goes without saying. This is so difficult, I think, not only because of this horrible trauma that these children have endured, but I mean, Edwin's the oldest sibling. He probably feels a bigger sense of responsibility than Kevin and Leslie. He also this is first year of middle school, right? Is he in 6th or 7th grade?
He's in 7th, is he not?
Okay. Well, either way, middle school, that's 3 of the toughest years you have as an adolescent. And he's going through it without a mother, and he's going through it not knowing what happened to her. And I can't even imagine what that must be like inside his head. And he's not getting professional therapy. He's not getting the specific relief he needs. And if I was going to say, Miss Coffey, if this, I know you're going to be on top of it, but if this therapist, we don't get something Friday or Saturday, I need to know. We're going to have to find something else, because I think we've left the world of chronic and we're now dealing with acute. We have an acute issue that has got to be addressed really quickly and pretty intensely. I'm going to leave all of that in the hands of the therapist as far as frequency and duration, but it seems to me like it needs to be once a week. I mean, that's what I would assume the therapist probably would want, because it's pretty extreme. And Miss Swallow said something earlier, and I've had experience with it in other cases. We could lose him. That's a reality here. We all need to be on top of that. It's a very, very real issue here. And I do not want to see that happen. So it's all hands on deck, and it's an acute situation. Are there any other orders that haven't been presented to me that might help? I think that I'm not a therapist. I don't claim to be one, and I'm not trying to diagnose or say anything, but it seems glaringly obvious to me that these grades are a symptom of this other issue, and until that issue gets addressed, it doesn't matter how much tutoring he has. I don't think it matters. Any of that matters if we don't get to the root of this issue. And if he's asking the kind of questions are, where was the wound on my mother's body? Obviously, it's all he's thinking about. That's it. That's the only thing he's thinking about, and we're not getting him the help he needs with it. So it's on us to make that happen. So if you need to call me directly, Ms. Coffey, about this therapist issue, get with Ms. Greenlee and we'll discuss that. If it gets into the realm of anything that might be ex parte, then we'll stop the discussion and we'll get Ms. Swallow on board. I just want to make sure it happens. I want to make sure that that takes place this week because we can't go another 2 weeks or 3 weeks. It's just, it can't happen. Anything else that we need to address today?
Not from the department, thank you.
Okay. Then I appreciate everybody's work on this case. I know it's a tough one. I know we've had some challenges for sure, but that's the order for today. And if we need to have another hearing between now and February, that'll be fine. We can do it. Okay. Thank you all for your time and your service. I do appreciate you. Nothing further. All parties are excused.